Thank you all for coming. What a well-behaved crowd. My name's Paul May. Newspaper reports on Colin Norris's case in the last few days have described me as a veteran campaigner, which is a nice way of saying very old and quite exceptionally worn out. But thank you all for coming. I think everybody's been talking with each other, but without pigeonholing everybody, among us here tonight, various groups of people. The booklet we've entitled Blinded by Science, and to the scientists here, we don't actually mean any disrespect to science or scientists by that title. The problem at Colin's trial, I would suggest, wasn't the scientists, it was lay people like myself understanding and misunderstanding of scientific concepts, and particularly what a hypothesis is. As one of the prosecution experts said at the trial, a hypothesis, I'm paraphrasing him, is basically as good as the next one that comes along, that where you have more data and more plausible information. And in Colin's case, we think we've now shown that hypoglycemia, low blood sugar, which it was claimed is extremely rare in non-diabetic people, is in fact quite common in elderly, hospitalized people with other serious conditions. We have many lawyers here tonight, and although there have been a great many innocent prisoners released from prison without the dubious help of us campaigners, or even without the media, I've never known a case which was resolved without the help of lawyers, usually acting for little or no money. And I know Jeremy will touch on this today. Several of us have been at the various events in protest at the quite outrageous reforms that Chris Grayling, the Justice Secretary, intends to bring in, which is not an exaggeration to say there'll be no lawyers dealing with these cases if these proposals go through of wrongful convictions. It's sometimes said that the media and journalists and writers help to convict people. Well, the media have also helped to free innocent people, and there are various journalists who have got a very strong track record, and there are more due along, in helping innocent prisoners come out of prison. And the final category of individuals here tonight are the most important. People who've been wrongly convicted, who've suffered many years of wrongful imprisonment, and their families, who know what June, Raymond and Colin's family are going through at the moment. And I welcome you all. There will be now two speakers. The first is June Morrison, Colin's mother, and Jeremy Moore, who is Colin's solicitor. June, over to you. Would you stand?
Yes, thank you. Thanks, Paul. I would, from my heart, just basically want to say thank you all for coming here tonight and for helping with Colin's campaign. All the support that he's had from people like Paul, the people that have written the articles for him, is really appreciated. And when he phones me from the prison, he does ask me to pass on his thanks to you all, because without you, we wouldn't be able to do what we're doing. And right away, way back at the very start, once Colin was convicted, and I came out of the court, and we were just left. There's no one there to tell you what to do. There's no support group to say to you, okay, your son's been convicted, this is what you can do, this is what you can't do. You're just left, and you're numb, you don't know what to do. You don't know who to contact, who to speak to. And it was actually Colin himself had seen an article that Bob Buffington had written, and he'd asked me to contact Bob to find out if Bob could help us in any way. And once we got to meet Bob, then Bob introduced us to Louise, and then Louise introduced us to all the other people. But that took a good 2 to 3 years. So in that space of the 2 to 3 years, we were just left with a family that had never been in trouble with the police. My son had never been in trouble with the police either, not knowing what to do or where to go. And once we got the support on board, then it just kind of escalated from there. And it's taken us nearly 5 years to get to this point. And hopefully the new research and the medical evidence that we've got now from the experts that wasn't available at the time of the trial will be able to take us through to the Court of Appeal. The CCRC have got the stuff just now, and I know they are taking their time, but I would rather they took their time and got it correct than try to rush it through. So basically that's, and I hope you enjoy the rest of the night. And please take Colin's booklet and his film, if you haven't seen it, that the BBC made, A Jury in the Dark, because that leads up to the things that Mark and Louise found. I mean, when they were going through all the paperwork and everything, they actually found stuff that we didn't know at trial, which again has been brought up and helped us a lot. And basically just to thank you all very, very much from the bottom of my heart for helping us as a family as well. Thank you. I'll pass you over to you.
And now, as I mentioned, no case can be resolved without many hours of hard, often unpaid work by solicitors and other lawyers. So Jeremy is Colin's solicitor, Jeremy Moore, my fellow Mancunian, from Carter Moore Solicitors.
I receive a lot of letters from individuals who seek to challenge their convictions every week, really, and it's far more than I can ever take on, and probably most of them, it's abundantly clear from the minute I receive them that they're going absolutely nowhere, and I unfortunately have to write back saying, unfortunately, there's nothing we can do to help you on this occasion. When I received Colin's initial letter and then had a chance to read some of the background to the case, there were immediately really a number of alarm bells that rang that caused me to think that maybe his case was not so cut and dry even at that early stage, and that there were matters that were at least sufficient to give rise to a concern with the conviction. I am, and I think we probably all are, highly respectful of the evidence that expert witnesses give and the assistance they provide to the court and to juries in helping them to assess the evidence in a case, particularly complicated medical cases like this one. However, when the evidence against the defendant is really solely founded on the basis of expert evidence, particularly when it roams into the area of statistics, there's unfortunately significant scope for juries to be misled. Statistical evidence can often be extremely persuasive to a jury, but also often misleading unless there's been sufficient relevant research into the particular area and the jury is made fully aware of all the material that there is on that research. Of course, we can all think back to tragic cases like Sally Clark, who was convicted of the murder of her own children, where, of course, the Professor Sir Roy Meadow testified that the chance of 2 children from an affluent family suddenly suffering infant death syndrome was 1 in 73 million. It simply arrived at that figure by squaring the 1 in 8,500 chance of the likelihood of a cot death in similar circumstances. Of course, the Royal Statistical Society later issued a public statement expressing its concern for the misuse of statistics in that case, arguing there was in fact no statistical basis at all for Meadows' claim. Of course, we're all aware of what happened to Sally Clark and the tragedy of that case. While she was obviously eventually acquitted, it had unfortunate tragic ending. Also the case of Barry George, which I was involved in myself, where a single speck of firearm discharge residue found in his pocket a year after the death of Jill Dando was said by the prosecution to have come from the gun that shot her. But on appeal and retrial, we were able to show that the particle was just as likely to have come from the environment, than to have landed in his pocket from that gun and still be there a year after the event. I truly believe that in the fullness of time, Colin's case will be thought of alongside those cases I just mentioned, and as a grave miscarriage of justice. In Colin's case, given the nature of the allegations, the expert evidence was of course key to his convictions. It should be borne in mind that only one of the deceased, Ethel Hall, were they able to undertake blood tests to ascertain levels of insulin and other vital constituents. And that said, even the tests carried out on her blood are extremely questionable given the techniques they did and didn't use. In particular, the blood taken from her wasn't frozen immediately, as is usually required to produce accurate results. So another sample had to be taken from her 6 hours after she'd been discovered in a hyperglycemic state. A C-peptide test that should have been carried out alongside the insulin test was not carried out for another 5 days, and no second test was undertaken to check the original results, as is the norm. No test also was carried out for a condition called insulin autoimmune syndrome, which could have explained the results. Forgetting for a minute these shortfalls, and even assuming that the results of Ethel Hall's tests were correct, which, as I say, we don't accept, and assuming that she did in fact die from an unlawful injection of insulin, there was, however, little to support the case that Colin was the person responsible. Hence, it being extremely important for the Crown to produce other supporting evidence by showing that he was not just responsible for her death, but responsible for the death of other patients. In the remaining 4 patients for whom he was ultimately charged, no tests were possible by the time the bodies were examined, and all of these women were certified as having died of natural causes at the time of their death. It was only after a re-examination of their records, with the backdrop of having Colin as a suspect in Ethel Hall's death, that the police set out to show that he was in fact a serial killer, and trawled through the medical records in all the relevant hospitals where he worked at the relevant times, picking out all apparent deaths involving hyperglycemic deaths, deaths where Colin was present at the time of death, or during a change of condition, or which were otherwise suspicious. So they only looked into those deaths in those hospitals where Colin was around, not where any other suspect or any other individual might have been present. No attempt whatsoever was made to look at the number of deaths where Colin wasn't around. The case against Colin for those patients was that they had also died as a result of hyperglycemic incidents, and that although it was too late to examine their blood to confirm injection of insulin, all of these women were non-diabetics. So the Crown's case was that the occurrence of hyperglycemia in such patients was so rare that the prospects of having 4 deaths in one location over such a period was so unlikely that it could be discounted. So again, I go back to what I said earlier about applying the statistics and putting it together with medical evidence and coming up with not actual figures for statistics in this case, but a glib statement that it's so rare as to be discountable. It was therefore vital for the Crown to establish that naturally occurring hyperglycemia was extremely rare, as without that the case against Colin would flounder not only in respect of the 4 patients, but also of course as supporting evidence in the case of Ethel Hall, as I say, given the lack of other evidence implicating Colin in that death. The Crown, however, were somewhat hampered by the fact that another patient emerged who it could be established had in fact died of naturally occurring hyperglycemia, which of course they were saying was very rare, but they discounted that as just a single chance event. The Crown, as I say, dismissed that case of naturally occurring glycemia, and at the trial they paraded purported expert after expert in the field, Professor Ferner and others, all of whom advised the jury that it's very unusual to see hyperglycemia in persons who are not diabetic. With this in mind, as his appeal solicitors, I instructed one of the world's leading experts in the field of insulin and the related insulin diseases, Professor Vincent Marks, an expert, in fact, whom the Crown themselves consulted in the early stages of the investigation. So there's no questioning his expertise in the area, even the Crown accept that he's one of the world's leading experts. And I asked him to advise on the accuracy of the Crown's experts on the rarity or otherwise of naturally occurring insulin to challenge the Crown's case that it is extremely rare. Professor Marks provided an initial report to us on the 15th of March 2011. He referred to a number of studies, some of which had been undertaken since Colin's trial, and others, although they had been carried out previous to the trial, were either not known to the experts at the trial or the experts had chosen not to mention them. Either way, the jury were not made aware of any of these studies and were left, as I say, at the trial with the impression from the Crown that naturally occurring hypoglycemia is an extremely rare event. He concluded that, contrary to current standard teaching, spontaneous hypoglycemia is in fact common in up to 10% in elderly, frail, sick people, especially those with low body weight and suffering from malnutrition, conditions that all of the victims in Colin's case suffered from. Professor Marks concluded from the study that there is little reason to believe that the hypoglycemia was anything other than a spontaneous response to their underlying illness. Contrary to expectations, he said, this is statistically, in other words, a naturally occurring hypoglycemia, was statistically more likely than the suggestion that it was insulin-induced. In October of last year, I asked Professor Marks to provide an updated report to ascertain if there had been any further studies since his last report. He reported that, in fact, another 2 studies had been undertaken, which confirmed that hypoglycemia does occur spontaneously in sick people, whether they are old or not, and that the more elderly and sicker they are, the more likely they are to suffer from hypoglycemia. Professor Marks concluded, the new evidence strengthens the conclusions I reached in my report about the reliability of the evidence on which Colin Norris was convicted. I do not accept that the conclusion of the prosecution experts are necessarily valid and believe that the diagnoses and causes of death given to each of these patients during life and immediately thereafter were probably correct. Each of these elderly women has had a sufficiently large number of risk factors for spontaneous hypoglycemia of the critically sick to account for its occurrence in their terminal illnesses. So, of course, this is an extremely different story to what the jury were told at the trial, and our forceful contention is that they were misled when they were told that hypoglycemia is extremely rare and unlikely to occur in, as they called it, a cluster of women in such a period, in such a place. We therefore say that the conviction must be unsafe on all 5 cases. And I believe that in the absence of such important supporting evidence, the Crown's case would fail at any future retrial. So that's what I say about Colin's case. Thank you.